Hello. Today I wanted to talk a little bit about the Foreign Money Judgments Recognitions Act, which is adopted in the United States in 37 states. And recently we had an experience for the past 2 years of litigating a case under this act in Florida, under the Florida version of the Foreign Money Judgments Recognitions Act. And because I'm very interested in cross-border litigation, especially with Russia, I wanted to talk for a few minutes in terms of cases from Russia and enforcement of Russian judgments in the United States. So, one thing to understand is that when there is a judgment from Moscow or from any other Russian court for a specific liquidated sum of money against an individual, there may be opportunity for enforcement of that judgment in the United States. In order to enforce the judgment, each state has particular procedures that need to be followed for beginning a new litigation in that particular state. In the case of Florida, the process is commenced by recording of the judgment in the Florida state court, typically, which is what we did. And once that recordation takes place, the debtor then has 30 days to object to the domestication of the judgment. And here we had an objection that was filed, and there are particular bases for the objection. And each state is in some ways different, but basically they follow the Uniform Foreign Money Judgments Recognitions Act, which was promulgated by the Uniform Law Commission. So there are mandatory and there are discretionary grounds for non-recognition of a foreign judgment. In New York, for example, under CPLR 5304, the foreign country money judgment is not conclusive if, one, the judgment was rendered under a system which does not provide impartial tribunals or procedures compatible with the requirements of due process of law. Two, the foreign court did not have personal jurisdiction over the defendant, or the foreign court did not have jurisdiction over the subject matter. So in other words, there is a provision where the court in the United States could determine whether or not a particular foreign country complies with what we deem to be requirements of due process of law. So American courts have certain standards. If another foreign court does not meet those standards, then the court could throw away this case. In the case of Russia, there is significant precedent in federal and state courts recognizing that Russian courts do provide adequate due process within the meaning of this rule. So if we're trying to enforce a Russian judgment, the chances of getting it thrown out based on this particular provision, which is a mandatory provision for dismissal, are low. And there is precedent now in Florida as a result of our case. There was also precedent in New York recognizing that Russian courts do provide adequate due process. Now, if the foreign court or the Russian court in this situation didn't have personal jurisdiction over the defendant, for example, if there's a default judgment, then that's different. In that situation, the judgment could not be enforced. Similarly, if the court just didn't understand or didn't have the capacity to render the judgment, didn't have subject matter jurisdiction. For example, in the US, federal courts have limited subject matter jurisdiction, whereas state courts have general jurisdiction. Then there are also some discretionary grounds for not recognizing a judgment. For example, under New York Civil Procedure Law and Practice Rules, CPLR 5304, the defendant in the proceedings in the foreign court did not have notice of the proceedings in sufficient time to enable him to defend. That's one of the grounds. In fact, in the U.S., notice is an important aspect of any proceeding. You have to have notice, and we have procedural rules for what that means, how to serve somebody, how to make sure that someone has an adequate opportunity to defend the case. 2, the judgment was obtained by fraud and deprived the losing party of an adequate opportunity to present his or her case. Of course, if there was fraud on the court or there was lying in connection with trying to get the judgment, that could be grounds. But that's tricky because most courts do not want to relitigate the cases. The proof has to be particularly strong. And this is, again, a discretionary ground. 3, the cause of action on which the judgment is based is repugnant to the public policy of the state. Very open-ended, has been tried, does not always work as a ground. The judgment conflicts with another final or conclusive judgment. That's important. Courts don't want to have conflicting judgments, but if there is no conflicting judgment, then the judgment should be enforced. 5, the proceeding in the foreign country court was contrary to an agreement between the parties under which the dispute in question was settled. 6, in the case of jurisdiction based only on personal service, the foreign court was a seriously inconvenient forum for the trial of the action. 7, the judgment was rendered in circumstances that raised substantial doubt about the integrity of the rendering courts with respect to the judgment. And 8, the specific proceeding in the foreign court leading to the judgment was not compatible with the requirements of due process. And 9, the cause of action resulted in a defamation judgment obtained in jurisdiction outside the United States, unless the court before which the matter is brought, sitting in this state, first determines that the defamation law applied in the foreign court's adjudication provided at least as much protection of the freedom of speech and press of that case as would be provided by both the United States and New York constitutions. That's only for defamation cases. So every case is different. Every case is different, and it has to be analyzed based on the circumstances and facts of that particular case. But I wanted to relay one general advice, especially to my fellow Russian colleagues, many of whom I'm connected with on Facebook or LinkedIn, or once in a while deal with on various cases. And this seems to have been completely overlooked by the various literature, and to date I haven't really heard anybody talk about it. One thing you have to realize is that the Russian judgments, the form in which the Russian judgments are typically rendered, is not super easy to understand. So if it's a 25 page Russian judgment, which goes on and repeats allegations, and repeats defenses, and repeats the hearings, and repeats everybody who was involved, and everybody who has a power of attorney to represent this person in Russian, and ultimately then decides something at the end, it's not always very clear. So when it comes to enforcement of the judgment in the United States, the clearer that Russian lawyers or Russian judges can make the judgments and to explain that these judgments are for a liquidated sum of money. This person owes this person, or this company owes this company X amount of money, period. The easier it will be to enforce it. One thing we were able to do is to take that judgment and convert it into a Florida judgment, which was a 2-pager. This company is owed X amount by this person. And I hope we'll be able to attain that in every case. But I think that one thing that can be anticipated is that Russian judgments, or some of them, could be challenged based on the lack of clarity in some of the judgments. So I think that going forward, especially given the fact that there is so much cross-border business, so much investment happening uh, from Russians into the US and vice versa, that it will be uh, much better to have clear, set judgments for liquidated sums of money that are brought over and sought to be enforced. So those are just a few comments. I look forward to working with everybody in the new year, and Happy New Year to everybody.